So I'm going to be talking about the domestic side of a piece of wider work.
Speakers.
Of streamlining domestic legislation, and going to be looking at that through primarily an administrative law lens with some reference to New Zealand Bill of Rights Act 1990. Going to cover three broad points. Firstly, streamlining and simplifying the consent process. Here, public participation is one of the key aspects, or has been a key aspect of the RMA, but it's been eroded by a series of ad hoc amendments designed to streamline and simplify the statute. For example, there were significant amendments in 2009 and 2017 that removed respectively the presumption in favour of notification and general discretion on local authorities to notify consent applications. Cumulatively, these amendments have, or these simplifying and streamlining reforms have reduced the likelihood of a consent application being notified to the point where only 2% of applications are now publicly notified. And although the recent Resource Management Amendment Act 2020 is designed to roll back these reforms, it's unlikely in practice to have that effect because the basic architecture of the previous amendments is left intact. The impact of these reforms on decisions about notification is stark. If an application isn't notified, you are shut out of the process. You have no rights of submission, no rights of hearing before the local authority, and no appeal rights either to the Specialist Environment Court on merits and law, or to the senior courts on questions of law only. The amendments in 2009 and 2017 have significantly narrowed the scope of the notification assessments that's applied by the senior courts. And whilst they take account of the normal range of matters that the senior courts do on review, such as relevant and irrelevant considerations, etc., there is arguably quite a focus on whether the local authority has acted unreasonably or irrationally in a Wednesbury sense. More recently, the COVID-19 Recovery Fast Track Consenting Act 2020 that's designed to urgently promote employment and support recovery and investment provides for selected consent applications for nominated projects to be decided by an expert consenting panel appointed by the minister, and it limits appeal rights by providing for appeals to the High Court and beyond that to the Court of Appeal on questions of law only. These appeals are expressed to be final, and appeal to the Supreme Court is precluded. Problematically, while judicial review is preserved, any application for judicial review must be lodged concurrently with any statutory appeal right. Now turn to my second point of alternative planning processes. Equally, in terms of ad hoc amendments, there's been a series of amendments by statutes around the RMA to affect the forward planning process, preparation of policy statements and plans by local authorities. An example of that was the process for the combined plan in Auckland. And most recently, we've seen the Resource Management Amendment Act 2020, providing for an alternative freshwater management process to address persistent issues in relation to freshwater allocation and quality. What's happening there is that there will be special hearing panels, freshwater hearing panels, who will be convened by the Chief Freshwater Commissioner, who's a person appointed by the Minister for the Environment. And similar to the combined planning process in Auckland under the Local Government Auckland Transitional Provisions Amendment Act 2013, statute that rolls neatly off the tongue, provision is made for appeals to the Environment Court on merits and law where panel recommendations are recommended, or to the High Court on questions of law only where panel recommendations are accepted. There's no specific ousting of Supreme Court jurisdiction in relation to that freshwater management process, but the right to judicial review is limited in terms of applications being required to be filed concurrently. The most recent piece of amendment literature is the new directions for resource management in New Zealand, the report of the Resource Management Review Panel that was released in June of this year. That dealt with some submissions that were made to the panel about delays in resource management, claims that the delays were the responsibility of appeals going to the senior courts. And although the panel made a finding that the number of those appeals was minuscule and therefore likely to have an effect, what the panel declined to do was to actually make a formal recommendation as to the continued relevance of the senior courts generally and the Supreme Court in particular in the resource management system. Come to my third point, whether the effect of these amendments in terms of their trajectory is having an impact on the rule of law. The senior courts in New Zealand have generally adopted a consistent approach to privative or ouster clauses following the Court of Appeal decision in bulk gas, which held that ouster clauses only protect decisions on questions of law that the relevant statute allows the decision maker to decide conclusively. And that position applies both to inferior courts and tribunals as well as to other decision makers. And the approach in bulk gas is also strengthened by the New Zealand Bill of Rights Act that affirms the right to judicial review and that requires statutory provisions to be interpreted in a way that's consistent with the rights and freedoms affirmed by the New Zealand Bill of Rights Act. Effectively here, the New Zealand Bill of Rights Act is requiring ouster clauses to be interpreted as permitting judicial review unless the only meaning that could be given to the relevant statutory provision is one that excludes judicial review. Various types of ouster clauses are found in New Zealand statutes, such as limitation of the scope of review clauses. An example of that is the recent Climate Change Response Zero Carbon Amendment Act of 2019 and finality clauses. And two examples of that are the statutes that I've already quoted from, the Resource Management Amendment Act of 2020 and the COVID-19 Recovery Fast Track Consenting Act 2020. It's also for note that following bulk gas, finality clauses do not appear to prevent judicial review for any area of law within or without jurisdiction. Restricted appeal rights are, however, problematic because an appeal against a decision to the High Court is necessary before an application for judicial review can be heard by the Supreme Court. It therefore remains unclear whether the provisions in the COVID Fast Track Act are intended to oust the jurisdiction of the Supreme Court completely. It's therefore likely that these provisions will be tested before the senior courts at some point in time, and that such litigation could expose political fault lines similar between government and the courts, similar to those that we've seen play out in the United Kingdom in Miller and the Prime Minister. Prohibiting a statutory right of appeal, the Supreme Court under the New Zealand to the Supreme Court under the New Zealand Bill of Rights Act, it's unclear whether the right to judicial review could be constrained in the same way. For example, Tom Bingham in his book, A Rule of Law, has put forward the proposition that it's unlikely that the judicial review jurisdiction of an apex court could be limited in some way. And we've had the Privacy International litigation again in the United Kingdom Supreme Court. The difficulty that's inherent in drafting a fully effective ouster clause, and that's my conclusion.